I will. No. How was it?
Please remain seated. Court is now back in session. All right. You ready?
Yes, Your Honor, we
Yeah,
are.
next.
Call Trinidad Chambliss.
Before we start that, y'all had some documents this morning. We never did make those documents exhibits, so I want them in the record. Mr. McLaughlin and somebody
Yeah.
else, and then you get two documents that are gonna be sealed. And,
Correct.
we need,
We just like to get you to say it on the record, if that's okay. Mr. Minor and I have agreed that
I know we stipulated to them, agreed to stipulate to them, but
Right.
I don't have them, but she needs to mark them, as an exhibit to the testimony.
Okay.
You okay with that, Mr. Manager?
Yes, sir, Your Honor. That's pursuant to our agreement.
These are just matters that we need to clean up and put into the record. Part of the 3-2 that will be, testimony will be come in by an affidavit and not by live testimony. So we'll mark those. Give me the name.
Yes, sir, it's, the first one is the affidavit of Michael Portner.
All right, Michael Gordon is, what will be marked as if this exhibit is it number 2? Number 1. Gordon will be number 1. And this is, wait till she gets it marked.
Exhibit 1.
All right, the next one is this.
The second exhibit is the affidavit of Matt McLaughlin.
All right, Matt McLaughlin, affidavit be marked as exhibit 2 and written in depth.
Your Honor, may we get a,
Just say.
yes, sir.
Exhibit 2.
Now you may proceed.
Yes, may we get Your Honor to rule on the record that Exhibit 1 and Exhibit 2 and the respective attachments to those exhibits are sealed?
On both of those,
Yes, sir.
on Gordon and McLaughlin.
Yes, sir, Portner and McLaughlin.
Those two exhibits will be sealed. You can mark that it's sealed, it says it.
Yes, sir, and I can get an envelope.
You got an envelope or something? We could, go ahead, right
We
there.
can do it later.
We just need an envelope to put these in and see. All right. Any other, what about the other two affidavits? I thought you had one to keep, other two.
They have already been filed in the court record. They were filed electronically on MEC, and they do not require sealing.
I understand it, but they're not made exhibits in this testimony.
Okay.
Do you have copies of it?
I don't.
Is it Higley and,
Yes, I've got a list here, though.
What about those Denise and Ms. Higley and these other, documents
Yes, I can identify them, and they're on the MEC in this case.
they're in the plea?
But I will give you a list of them. There's document number 13, which is an affidavit of Dr. Anthony Howard that includes Dr. Howard's letter of October 2025. There is document number 16, which is the affidavit of Taylor Hall. Document number 17, which is the affidavit of Austin Thomas. There's also document 5-2, the Brett Knight with a K letter. Document 5-3, the letter from Coach Tony Anise. Document 5-4, the letter by Sarah Higley. Document 5-5, which is an NCAA Division I directive. Document 5-6, which are medical records of Trinidad Chambliss. Document number 16, which is the NCAA rationale for denial, dated January 9, 2026. And there are some other documents I have with me, Your Honor, that have not been MEC filed, and I can offer them as exhibits. No, sir. There are things of which we would ask the court to take judicial notice, like newspaper articles, excerpts from the NCAA Sports Medicine Handbook, an NCAA Sleep and Wellness flyer, and we're going to offer, when Trinidad testifies, a photograph.
No, Your Honor, and for purposes of the NCAA's documents, pursuant to our stipulation, the documents attached to our response, while not, they're not tied to any particular witness, but opposing counsel is stipulated to the admissibility of those as well.
That's correct.
Well, they're in the pleadings, right? They're attached to the pleadings.
Everything except the 5 last items I mentioned, which I have with me.
I would, if it's agreeable to the parties, the documents that he just identified, that they've been filed at the NEC and are part of the record, they will be part of this record, part of this hearing. And, I would say some objection.
No objection.
And then the 5 documents you have now,
Yes, sir.
you could introduce those as collected exhibits. Let's mark them as collected exhibits.
Yes, sir.
Again, for those of you who have spectators, these are housekeeping matters that need to be done. The court is just trying to make sure that the record in this case is complete, and if there's some appeal of it, then the court that would be looking at the best option of what's been done.
Okay. Yes, sir.
Oh,
Yes, Your Honor.
Let her mark that, I'm sorry. Yes, she has to tell me when she's ready.
Exhibit 3.
All right. Now you may proceed.
Thank you. Call Trinidad Chambliss.
All right, Trinidad, come around.
May we proceed?
You may proceed. You ready?
Sir,
All right.
Trinidad, how old are you?
23,
And where's your home?
Grand Rapids, Michigan.
Are you enrolled in school?
Yes, sir.
Currently enrolled in school?
Yes, sir.
Where?
University of Mississippi. Ole
Okay.
Miss.
You're gonna have to speak a little louder so I can hear you, okay? Um, in the fall of 2025, did you compete in college athletics?
Yes, sir.
What team did you play for?
Ole Miss.
Okay. Did the team have a good year in 2025?
Yes, sir. We had a great year.
Okay, now, as quarterback, what moments of last season stand out for you?
Just our regular season, having the best, regular season in Ole Miss history, and then having a great run in the college ball playoffs. A lot of adversity we had throughout the season with our coaches. Yeah, proud of our guys, proud of our team. We had a good year.
All right. Played in the Fiesta Bowl, right?
Yes, sir.
What do you think about the last play?
It's a heartbreaking topic for me. I feel like it was pass interference, but it's tough for a referee to call that.
In addition to a team journey, this past year has been quite a journey for you, right?
Yes, sir.
This time last year, in February 2025, could you even have fathomed everything that was going to happen to you over the course of the year?
No, sir. It's been a crazy ride, and I'm honestly grateful.
How many seasons do you believe you have left to play college football?
One more year.
When you came to Ole Miss, how many seasons did you believe you had to play?
2 years.
Why do you believe you had 2 years to play when you transferred to Ole Miss?
Because I was told by me by Ferris State, Coach Anise.
Okay. And what did the Fair State coach tell you?
He told me that I met up redshirt in 2022, and then I had 2 more years of eligibility to play.
Okay. Do you know whether or not Fair State submitted or filed any kind of paperwork with the NCAA regarding your medical red shirt in 22?
No, sir, I did not.
Okay. Did anyone ever tell you there was something you had to do personally in order to document that?
No, sir.
Did you assume and I guess trust that Fair State would do whatever it was supposed to do to get you declared a medical red shirt in 2022?
Yes, sir.
I want to talk about a long period of time. All right? So this period of time starts in 2020 with you getting mononucleosis, and it goes all the way through the end of 2024 when you had surgery to remove your tonsils and adenoids. All right? In your words, as best you can, just describe what that health course and medical course was like.
Constantly being sick, having a roller coaster of being sick and then feeling better, constantly being, fatigued and tired throughout the day, not getting enough sleep.
Okay. Well, you said roller coaster. What do you mean?
There's times where I feel good, and there's times where I feel really bad.
As far as the fatigue goes, even if you're in that time period, even if your throat felt a little bit better, was the fatigue still an issue?
Yes, sir.
When did the fatigue go away?
Until I got my tonsils removed.
Do you snore?
Not anymore.
Okay. How bad did you snore after your second bout of mononucleosis?
It was pretty bad. My family can attest to that. My friends can say that I was a pretty bad snorer.
Okay. And did you come to learn what condition you had that was causing you to snore and disturbing your sleep?
Yes, sir, it was sleep apnea.
And how did you learn that?
Dr. Howard had told me that.
Did the fatigue affect you in other ways? Like, for instance, nutritionally?
Yes, sir, I was very tired, had lost appetite, and that has to do with me having, sore throat most of the time. So yeah, lost appetite and just lack of energy, to be honest.
Right. Did that present any problems in your attempts to gain weight?
Yes, sir, most definitely.
Okay. May I approach, Your Honor?
You may.
I'm going to hand you the first page, Exhibit 3. Tell me who that young man is.
It's me,
Okay. When was that picture taken?
my second year at Ferris State.
Okay. What did they take those pictures in the preseason before the fall game season starts?
Yes, sir.
Okay. It says on there, I think, the letters R, FR. What does that mean?
Redshirt freshman?
Okay, so that would mean it's your second year at Ferris State.
Yes, sir.
How tall are you as shown on that exhibit?
It says I'm 6'1",
How much do you weigh as shown on that exhibit?
176 pounds.
Okay. Did you in fact weigh 176 pounds when you reported for football at Ferris State in 2022?
Yes, sir.
For lack of better words, were you skinny?
Yeah, I was very small, not in really good physical shape.
Okay. And why do you believe you weren't in good physical shape at the time that photograph was taken?
In the summer, preseason, before football season, it's my job to get in good shape, and I just wasn't able to do that based off my conditions.
Okay. What did you experience in the summer of 2022 when you would go try to work out and condition and build your endurance? I mean, what did you experience?
Shortness of breath, me not being able to finish workouts, just having a tough time, catching my breath and, just pushing through workouts, to be honest.
Okay. All right. Is that picture a fair and accurate depiction of you and how you looked when you reported to Ferris State in 2022?
Yes, sir.
Okay. What do you think about how that kid in that picture looks?
He looks tiny.
Okay. All right. Did you give it your best effort over the summer of 2022 to train and condition and develop to where you would even be in football shape?
Yes, sir, I tried my best.
Would your mother try to encourage you?
She would.
In what ways?
Try to push through it.
Okay. And that's what you tried to do, right?
Yes, sir.
When did you start gaining weight?
2023.
Okay. And did that help you get in shape, gaining the weight?
Yes, it did.
Okay. And what did you do to gain weight in 2023?
Drink more protein shakes, kind of change my diet, get more sleep if I could.
Okay. Were you doing anything to avoid crowds or places where it might be a lot of people who could be sick?
Yes, sir.
Okay, and why were you doing that?
To prevent me from getting sick. I do that once I do get sick. I'm down for a couple of days, and it's not a good sight, to be honest, and I don't feel great.
Have you noticed that, have you had a cold since you had your tonsillectomy?
I have.
Okay, and compare a cold after your tonsillectomy to a cold before your tonsillectomy. How are they different?
Before I had my tonsillectomy, a regular common cold, it would be 3-4 days before I would start feeling any better. Now, if I feel like I'm having a sore throat or feeling like I'm getting under the weather, it's usually just a day, to be honest.
When you left the visit with Dr. Howard that happened on August 1, 2022, the moment you walked out of his door, okay, did you still have an infection?
Yes, sir.
How long did the infection continue?
I don't have the day, but it was a while.
Were you back at school when you finally started feeling a little better?
Yes, sir.
What part of the school year? Well, I mean, September, October, November, December? When would you put it? Best estimate?
When I got back,
Yeah,
during the fall, September.
okay. You had an appointment, I think, with Dr. Howard on a day in September of 2022, but you didn't make the appointment.
Yes.
Can you tell us why you didn't make that appointment?
As a student athlete, I have class, I have football obligations as well. And Big Rapids and Grand Rapids is an hour away. It takes a lot on my day to go down, go to the appointment, and then go back. So it's usually the whole day. So I couldn't afford to miss class or anything with football.
Okay. But you already knew, even in September of '22, what was going to be required to fix your problem, right?
Yes, sir.
And what was that?
Surgery.
Okay. Now, you didn't have the surgery until December 30th of 2024?
Yes, sir.
Why did you put it off that long?
You know, me as a competitor, a student athlete, I didn't have a role on the Fair State football team at that time. And at that time, in the younger age, me chasing my degree, I knew I had to stay on top of my classes. And I knew at that given point it wasn't the right time in September of 2022 to do that. So ultimately, later in my college degree, I already had a great year of football. That was the right time to, get my tonsils removed.
Okay. So, lack of better words, did you want to solidify your position on that team before you had surgery? It might take you out several weeks.
Yes, sir.
Let me talk to you about when you went back to Fair State in the preseason of 2022. All right? You had just seen Dr. Howard, correct?
Yes, sir.
Okay. After about 2 weeks into the preseason, did your head coach, Tony Anise, meet with you?
Yes, he did.
Okay. Can you tell us about that conversation you had with him?
Yep, he pulled me into his office and let me know that he was going to redshirt me.
Okay. Did you discuss with him your medical illnesses at that time?
Yes, sir, I did.
Okay. Did he tell you whether or not you were going to get any playing time in 2022?
He said that I would not play.
You've heard some witnesses in here today, including Dr. Dye, testify about how painful the surgery is. Would you like to comment on that?
Yes, sir, I can.
Okay, go ahead.
It's very painful. It was like torture, to be honest. Felt helpless. I really couldn't do much. Even sleeping was, very brutal. I was waking up in the middle of the night, just in pain. It was the worst sore throat I ever had.
Starting in the fall of 2022, after you saw Dr. Howard, did you take medicines on really almost a daily basis?
Yes, sir, I did.
Can you tell us what medicines you were taking over that long period of time, up until you really had your surgery?
Yes, I had Flonase, and then Singular whenever I had it. I also took Claritin, and then Dayquil, NyQuil, and then a bunch of cough drops as well.
Okay. You heard me ask your mother if she was a walking pharmacy. Did she serve that role for you?
Yes, sir, she did.
All right. Did you get to play any football in 2023?
A little, yes.
And by that I mean against other teams,
Yes, sir.
right? What were the circumstances in those games when you got a chance to play?
Fair State is a pretty good Division II program. The time that I would get in, it would be garbage time, to be honest. Usually we'd be up a lot, and they would put me in.
You went to see your ENT in November of 2024, 1 month before you had surgery.
Yes, sir.
Did you tell that ENT that you met with about any flare-ups of infections that you had had over the year before you walked in to see him in November 2024.
Yes, sir.
And what did you tell him?
Told him that I was constantly being sick, constantly tired, fatigue was never went away. And yeah, I had constant flare-ups, constant sore throat, just felt crappy.
Okay. You were able to perform pretty well in 2024,
Yes, sir.
okay? Even though you still had these conditions that would recur, right?
Yes, sir.
What do you attribute that to?
Me being able to perform.
Yeah, you can be able to perform pretty well in 24, even though you still have these chronic illnesses.
The medicines that I took, I was taking Flonase, Dayquil, Nyquil, and Claritin, kind of helped me tolerate the symptoms that I had.
Okay. Did you feel like you were in better physical condition in 2024?
Yes, sir, definitely. I feel like I was definitely better physically conditioned to how I was feeling, yes.
All right. Had you gained weight by 2024?
Yes, sir.
What do you weigh now?
200 pounds to 205.
What did you weigh? Well, we know what you weighed in 2022. We have a photograph of it. What do you think you weighed at Fair State in 2024?
Probably 195 to 200 pounds.
It's an odd question, but I need to ask it. Do you think your medical condition was better in 2024 than it was in 2022?
No, sir.
Okay. When do you think you were the sickest? That's what I'm asking. Were you the sicker in 2022, in the fall of 22, or were you sicker in 2024?
2022.
What's been your experience since your surgery with respect to the problems that you had? You know, your chronic tonsillitis, chronic adenoiditis, and, the swelling, the adenotonsillar hypertrophy of your tonsils.
After the surgery,
Yeah.
I feel much better. I'm not getting sick as often as I did. The fatigue has gone away. I'm more active. I'm more aware, and I feel better. Just overall feel 100% healthy.
Have you felt 100% healthy since you recovered from your surgery?
Yes, sir.
Did you feel anywhere close to 100% healthy before you had your surgery?
No, sir.
How many actual football seasons have you competed in?
Only 3.
Okay, let's count them. Okay, 2023,
Yes, sir.
2024,
Yes, sir.
and then last season at Ole Miss, 2025.
Yes, sir.
We're here today because we're asking the court for something, right?
Yes, sir.
What are we asking the court for?
I'm forced to go to college football.
Okay. Do you think that's a fair request?
Yes, sir.
Why do you think it's fair?
Because I'm asking what the NCAA has in their rule book. All athletes get 4 years of eligibility.
At any time before you had your surgery in 2024, were the medical conditions you suffer from something that were in your control?
No, sir.
Now, what do you think the benefits will be to you if you're able to play football at Ole Miss in the fall of 2026 and undergo an additional year of development as quarterback?
I feel like just having the experience as a college football athlete, my coaches, players, and the community of Oxford would be amazing. I feel like we can accomplish a lot. I feel like the team this year would be better than it was last year. And yeah.
Okay. Do you think that additional year of development will bode well for your future once you voluntarily choose to go to the NFL?
Yes, sir.
Okay, in what way?
Just another year of experience. My journey is a little different than others. I was at a Division II program, and then now I was at Ole Miss for 1 year, not even a full year. So I feel like another year, some full experience and another year of development, talking with my coaches and players, will be good for me for that NFL.
Do you think that an additional year of development will make it more likely that you go higher in the NFL draft?
Yes, sir.
Are there any other benefits if you're not able to stay at Ole Miss next year? Are there any other benefits you'll lose or miss out on?
Yes, sir.
What are they?
NIL, rev share.
Okay. A rev share agreement was offered to you in December, was it not?
Yes, sir.
Okay. Were you able to sign that agreement?
Yes, sir.
Oh, you signed the rev share agreement?
Oh, no, no, no.
Okay. But don't you have to be eligible to get a rev share?
Yes.
Okay. So you weren't able to sign it because of all this that's going on, right?
Yes, sir.
Okay. Let's talk about commercials, television commercials. I saw one with you in it. It was on behalf of AT&T. I think it was filmed at Ole Miss, right?
It was.
And it was broadcast nationwide.
Yes, sir.
Okay. What was that experience like?
It's amazing. Acting is a little bit harder than what people think it is.
Yeah.
But it was really cool to experience that.
Do you believe that if you get this fourth season of competition, that your relationship with AT&T will continue?
Yes, sir.
Okay. Do you believe there'll be other brands that you'll end up working with?
Yes, sir.
Without naming the brands, are you in talks with other brands to advertise and market on their behalf?
Yes, sir.
I don't have anything further at this moment, Your Honor.
Good afternoon, Mr. Chambliss. Thank you for being here, and congratulations on an outstanding career so far. Just want a couple quick questions. Clarifying earlier, was it your testimony that you were more sick in 2024 or 2022?
2022.
Okay. So what was it that made you seek surgery in 2024?
Like I said before, I wanted to establish my role as a student at Fair State before I had the surgery. And in 2022, just wasn't the right time.
Have you had the opportunity to review your medical records?
A little bit, I would say. Not, yeah, no.
Do you have any reason to think that anything that was written in those records is inaccurate or incorrect?
Object to the question, Your Honor. It's overly broad. The question, my objection is the question is overly broad because he's asking Trinidad about 90 pages of records that are not in front of him. And he's trying to get him to vouch for everything in that record.
Well, he's on cross-examination in Mississippi, he's got a wide open rule, he can ask him about what he wants to do. It's his reason, so I'll allow you to ask the question, if he doesn't understand it, he doesn't have to answer it.
Understood. There's a medical record from December 21st, 2022, which I'll describe as kind of your postseason visit with Dr. Howard. Do you recall that visit?
Yes, sir.
As part of this medical record, it says that, and this is summarizing from Dr. Howard's perspective, what you told him, it says he has not had any significant tonsil infections since I last seen him and have not been bothering him. Do you recall telling Dr. Howard that you had not had any tonsil infections during the 2022 season, that they had not been bothering you?
I do not recall that, no.
Do you have any reason to think that Dr. Howard's written down something inaccurate?
No, sir.
Did you practice during 2022?
I did.
Did you, were you limited in any way during those practices?
No, no, sir.
In 2023, and remind me, what do you think got better for you in between 2022 and 2023?
Me being able to tolerate the symptoms because of the medicine.
And that the medicine was Flonase, and what was the other one?
It was singular whenever I had that. If I didn't have that, it's Claritin.
When you were discussing with your coach your medical red shirt that you described it, your mother testified earlier that y'all are aware there are differences between the Division II eligibility rules and the Division I eligibility rules. Do you recall your mom saying that? Do you agree with that?
Yes, sir.
Do you know what those differences are?
Not off the top of my head, no.
Do you know that under the Division II eligibility rules, it's not a 5-year calendar, it is a 10-semester calendar?
Okay.
Did anybody from Ferris State ever tell you that you could enroll part-time during a semester and pause your eligibility clock.
I think it was mentioned before, but not a lot though.
That was the plan though, wasn't it? You would take a part-time semester to allow yourself to come back in the fall of 2026, correct?
You could say so.
And that was at the Division II level, right?
Yes, sir.
And when you transferred to the Division I level, the rules changed, correct?
Yes, sir.
And the plan that Ferris State had for you was no longer applicable because you were playing under different rules, right?
Yes, sir.
And that's kind of why we're in the situation we're in, right? If you were playing Division II football, there's no reason for this hearing, correct?
Yes, sir.
And so when you say you have 2 seasons of eligibility left when you transferred, what you mean is you have 2 seasons of eligibility left at the Division II level, correct?
Say so, yes.
You're going to play football again no matter the outcome of this hearing, aren't you?
I would hope so, God willing.
I have no reason to believe you won't. You've got NFL draft potential, don't you?
I would hope so.
If you enter the draft, you've been told that you will be picked, correct?
I mean, there's been talks and conversations, but it's nothing for sure.
Would you agree with me then that the question before the court is not whether if you play football again, but where you play football?
Can you repeat that?
Yeah, would you agree with me that the question really before the court is not if you're going to play football again, but where you're going to play football again?
Yes, sir.
I don't think I have anything. Thank you so much for your time and congratulations again.
Appreciate it.
No further questions?
After that, I'm a little bit confused. My understanding of what Dr. Howard said, during your 22 season, that's what's been in question here today, is not whether you're gonna keep playing football or not. The question is whether or not you're gonna get a waiver, and that you're eligible for a waiver on the NCAA rules. Is that not what you're asking for?
Yes, sir.
And in 2022, you just got through saying that you didn't have any issues. Were you, my understanding that you, other records have said that you complained to trainers, during that 22 period, you were out there, and you did a scout team, but that you wasn't up to par. Were you up to par or not?
No, sir.
Well, I didn't understand why you were saying what you were saying a while ago, because 2022 is the year that we're looking at.
Yes, sir.
Did you go in and report to the training staff, anybody that you were having trouble?
Yes, sir, multiple times.
And I think Dr. Howard said you didn't have any flare-ups, but you still had some swelling and so forth when he checked you in December after you had it 3+ in August of 2022. You still had some swelling in your adenoids and your tonsils, did you not?
Yes, sir.
Well, was it bothering you or not?
Yes, sir, it was constant. It was like a roller coaster.
And that's why you believe that you couldn't play during 2022.
Yes, sir.
You never played it down in 2022.
Not one.
All right. Based on what I've asked, do you want to ask me anything further?
Just one issue. The summer 2022 was hard on you, right? Medically?
Yes, sir.
And did that interfere and really prohibit your ability to train, condition, and develop, just to even get into shape to have a shot at taking the playing field?
Yes, sir.
Okay. Thank you.
Anything further to ask you?
No, sir, Your Honor. Thank you.
You may step down.
Thanks, sir.
Any further witnesses?
No, sir, Your Honor. We rest.
Petitioner ready. Ball's in your court, Petitioner, or Mr.
Your Honor, we're prepared to make closing argument, but the NCAA will not be calling any witnesses.
NCAA. As far as witnesses concerned, you ready?
Correct, Your Honor.
All right. Do you need a few minutes to prepare, or who's gonna make the closing argument?
I am, Your Honor, I'm ready.
Are you ready? All right.
Your Honor, what we'd like to do is have Mr. Byers make the first part and allow me to make a short rebuttal.
How much time do you think it will?
Not much.
Well, for Your Honor, I'm gonna need a good bit, because there's a good bit of testimony that happened today, so, I'd like an opportunity to fully address all the testimony that was raised here today.
Well, we're not gonna be here till 6 o'clock.
No, it won't take that long. I promise you it won't.
I will give you a fair time, Mr. Minor, since, they're gonna make an opening and then make a closing, and you can clean up, you can, be like, Baker, not Baker Donaldson, but the other big firm, I can't think of his name right now, Butler Snowden, George Butler. He made a statement, he's gonna go through the woods and eat every crawfish that's on the ground, and leave nothing but the shell. So I'll give you a chance to.
Just eat a couple.
All right, Mr. Myers.
May I proceed, Your Honor?
You may.
Thank you. As the court well knows, and we can tell, that the court has reviewed all the papers here, with possible exception of all the NCAA rules in the book there. The preliminary injunctions in Mississippi should be granted under 4 scenarios that the court's well aware of. And I want to address each one of those after I go through the elements. There exists a substantial likelihood that the plaintiff will prevail on the merits. The injunction is necessary to prevent irreparable harm. The threatened harm to the applicant, here Trinidad, outweighs the harm that the injunction might do to the respondent, and that the injunction is consistent with public interest. Those are the 4 elements that we're talking about. And in the court's weighing of those 4 elements, those factors enjoy a direct relationship with each other such that the strength of one can make up for the weakness of another. I don't know that that's necessary here, but that's the law of the state of Mississippi. The first factor, there exists a substantial likelihood that the plaintiff will prevail on the merits. Trinidad is clearly a third-party beneficiary of the contract between the NCAA and Ole Miss, and the court doesn't have to make a leap in order to find that. As stated in our briefing, the NCAA's rules agreed to by the NCAA and its member institutions constitute a contract. The Constitution and bylaws of the NCAA are binding agreements between the NCAA and its members, and here's the key, for the benefit of the student athletes. So, what we have in this case is that Trinidad is clearly a third-party beneficiary of the contract. The NCAA owes Trinidad a duty of good faith and fair dealing, which I thought was interesting in the briefing by the NCAA, that this was an amorphous duty. Your Honor well knows from practicing, and we all know from drafting up jury instructions. Well, Your Honor, as the court well knows, there's nothing amorphous about a clearly contoured piece of Mississippi law that is inherent in every contract that exists in this state. And so that's the second part of that first factor. And then finally, the NCAA has breached its duty of good faith and fair dealing. And how has it done that? The NCAA, as we've seen here today, has essentially ignored 91 pages of medical records. It has ignored the fact that Trinidad, we've seen many comments about, well, tonsillitis. This is not a situation, an isolated situation of tonsillitis. We have a 2020 bout of mononucleosis, a 2020 bout of COVID, a 2021 scenario that was so scary that Trinidad had to go to the ER and wear a heart monitor. And right, when he was exerting himself. And then, of course, the tonsillitis and adenoiditis. It's easy for me to say. Now, Dr. Howard is a board-certified ENT. And I think Your Honor asked the question during some of the testimony, perhaps from Ford also a board-certified ENT, about the tonsillitis. And the grade 3+ tonsillitis is not just something that doesn't affect the airways. It is a situation where between 50 and 75% of the airways blocked. And so that's a significant finding. And so the question really becomes, when it comes to Trinidad's medical condition, where's the NCAA's medical proof? We have one affidavit from a person named Jennifer Henderson, who is a lawyer for the NCAA. And with all due respect to Ms. Henderson, we prefer that this court pay more close attention to the opinions of medical doctors, not juris doctors. And so I've struggled with the question, why? With all of this medical information that was contemporaneous, why Trinidad's case? And so it occurs to me that the only possible answer could be that the NCAA believes that Ole Miss concocted this medical red shirt situation only after Trinidad became a star. And Your Honor has heard proof, and it is replete in the record that that is just simply not the case. This ignores what Trinidad was told at Ferris State, that he was medically redshirting. It ignores a broadcast by the NCAA with two announcers who, by the way, come to the schools, as Your Honor well knows, and do production meetings and find out all they can about the teams before they get behind the TV screen and just pontificate. The announcers at the NCAA Division II Championship in 2024 specifically referenced a medical redshirt that Trinidad had received after his redshirt freshman season. These are well before Trinidad had a twinkle in his eye about coming to Ole Miss. We have news articles that Mr. Liston has just mentioned to Your Honor a little while ago that refer to 2 years of eligibility and medical redshirts. And so really the question here is, has the NCAA, under the totality of the circumstances, treated Trinidad fairly? And the answer to that is no. Now, the second factor, an injunction is necessary to prevent irreparable harm. I have found it interesting that the NCAA's own statements on this are critical. Every game is crucial to a student athlete and their team, and courts have repeatedly found that college students suffer irreparable harm when they are denied the opportunity to play sports. And I saw a statement from the NCAA involving a Tennessee case recently where the NCAA referred to the life-changing opportunities that only college sports create. It is also a fundamental rule that college athletes should be entitled to 4 seasons of competition. And Your Honor's questions to Trinidad hit this nail on the head. He has had 3 seasons. He is simply asking this court for a 4th season of competition. Now, what are the irreparable harms? We heard from Coach Judge. The ability to develop appears to be absolutely crucial, both at the college level and at the professional level. We heard testimony today about 1-season guys and at the quarterback position, and how important it would be for Trinidad to receive another year of development in a system that, frankly, he was late to the game on. He did not participate in the entire quarterback club that they have during the preseason. He got here late. His quarterback school got here late and was not able to participate in that. So he has been deprived of a substantial opportunity to develop himself. Now, there are other measures of irreparable harm: postseason hopes, NIL, showcasing abilities in front of the entire country, which of course Trinidad has. And the NIL aspect of this is not readily quantifiable at this time. As Trinidad testified to earlier, there are potential other avenues out there that he could participate in with NIL. And let's face it, Dr. Dye said it. The question was asked, did you know Trinidad Chambliss last year? He said, I've never heard of him. And with all due respect to Trinidad, many of us had not. In 1 year, he has become the face of college football in the South. And so he deserves that opportunity to continue to develop. Now, this damage is imminent. It is imminent. On the Friday after the ice storm, Trinidad and William came to the office in order to look over some documents, and only the next day was Trinidad going to fly out to California in order to train for the NFL draft. That is late to the game. We're looking at the combine occurring in less than 2 weeks, February 23rd of 2026, and the NFL draft occurring April 23rd of 2026. We are right on the cusp of Trinidad having to go one way or go the other. And the evidence supports the fact that the medical red shirt is the appropriate way to go under this preliminary injunction factor. Now, the third factor, the threatened harm to the applicant outweighs the harm that the injunction might do to the respondent. You know, I'm struggle to find what the harm to the NCAA is. Trinidad is not asking for the rules to be rewritten. He's just asking for them to be applied fairly. And the NCAA has this process in place. They call it an extension of eligibility waiver. They're granted routinely. And so there's no harm to the structures of the NCAA in granting Trinidad a fourth year of competition. And I think it goes without saying, Trinidad Chambliss is not an outlier. He has not been to play professional sports and come back to Ole Miss. He is not seeking a 9th year of eligibility. He simply wants a 4th year of competition. The fourth and final factor on the preliminary injunction,
The Montana player?
I'm expressly talking about the Montana player. I believe he was awarded his 9th year of eligibility.
What about Carson Beck playing about 6 years?
Well, I found Carson Beck's, the irony was pointed out in our briefing that the NCAA's decision on Trinidad came the day after the Fiesta Bowl, and I happened to watch some of the interview of Carson Beck, and they asked him about classes. He wasn't even going to classes anymore.
Last 2 years.
Trinidad's enrolled in Ole Miss and looking forward to getting back in school with his teammates. And so, in terms of the public interest, allowing student athletes to participate in 4 years of intercollegiate competition is consistent with the fundamental principles of both D1 and D2. It is replete in our pleadings, and the legitimate interest includes what Trinidad testified to. In the public interest, he wants to be back with his teammates. He wants to be back with his coaches. Your Honor well knows from living in this area for so long, the public interest is well served when Ole Miss athletics is successful, unless you're buying a house. And so the fact is all of these different factors are favorable to the imposition of a preliminary injunction in this case. Now, the irony, and I'll sit down after this, is that the NCAA, if Trinidad does not get his 4th year of competition, is actually losing one of its most popular players in its most popular sport. And so the public interest is clearly served across the board. Your Honor, we request that the preliminary injunction be granted, that Trinidad Chambliss be allowed to return to Ole Miss for his 4th year of competition. Thank you.
Thank you, Your Honor. Your Honor, since 9:30 this morning, what's happened in this courtroom has been, it's been a hearing asking you to make this decision differently. This has not been a hearing that's established that the NCAA has acted in bad faith. They don't talk about bad faith. Mr. Byers didn't use the phrase, but that's what they have to prove in order to get this injunction. They haven't come in here and shown you that the NCAA's decision, based on the NCAA bylaws, based upon consideration of the contemporaneous medical evidence, was bad faith, because they can't. What they did instead was bring you a bunch of information that wasn't submitted to the NCAA at the time, that's not contemporaneous to what was going on with Mr. Chambliss at the time. And they're saying, well, we're not here attacking the NCAA's decision based on their bylaws. We want to give you all this other evidence. We want to bring in other doctors, and we want you to make the decision differently. But, Your Honor, the lawyers in this room know that that's not the decision that you're charged with making. The decision before the court is not whether you would have decided it the same way. The decision before the court is whether the NCAA acted in bad faith when it made the decision pursuant to the bylaws that were adopted by the NCAA member institutions. And there isn't a scintilla of evidence that that decision was made in bad faith, not a single solitary bit of it. So I'm going to talk about the law, and I'm going to talk about the lack of evidence about the law, and not talk about fairness and how he would benefit. Under the law, there simply is not a right to an injunction. And I'm going to go through each of the factors that Mr. Byers went through, and I'm going to talk about the law and not amorphous references to fairness and benefits. And based on that law, Your Honor, there's no basis for an injunction. Mr. Chambliss, there is no evidence that Mr. Chambliss was incapacitated in 2022. In fact, all of the evidence says otherwise. All right, so what does the bylaw say? You have to show that you were deprived of the opportunity to participate in a season due to circumstances beyond the control of the student athlete. And the circumstances beyond control include situations clearly supported by contemporaneous medical documentation, which states that a student athlete is unable to participate as a result of an incapacitating physical or mental circumstance. Earlier, when my colleague was examining Dr. Dye, there was a reference to, we don't know what incapacitating means. We don't know what that term means. We do, because it's in the bylaw. It means that you're unable to participate. And Mr. Chambliss participated. Mr. Chambliss excelled. Mr. Chambliss won the D2 championship at a time when the physician who testified claims that he was incapacitated. Your Honor, that doesn't make any sense.
That's not exactly true, Mr. Rogers. You're talking about 2023 and 24. He didn't play in 22. That's when he was incapacitated, he claims to be.
Your Honor, the testimony is that he was incapacitated because of all the conditions that we've heard about today, but those conditions persisted up until he had a surgery later on in his career. But what I'm saying is, before he had that surgery, he participated, he played, he practiced. He was in the 2023 spring game. He played 5 games in 2023 before he had this surgical procedure, at the same time that he was taking the Singulair and the Flonase that he said was helping his symptoms. He was not unable to participate. There is a single set of medical records from 2022. And what the NCAA did was they looked at the bylaws, they applied the bylaws that say clearly supported by contemporaneous medical documentation. And so they looked at the 2022 medical information, and what does it say? Mr. Howard's 2022 notes say Mr. Chambliss wants to hold off on surgical intervention in favor of medical management, and that he would see him again in 6 to 8 weeks. We know that Mr. Chambliss did not come back to that doctor and did not see him in 6 to 8 weeks. So on August 1st, 2022, a full month before the first game of the season, he goes to see the doctor and tells the doctor that he don't want to have surgery. And on December 1st, 2022, after the season, he comes back and he says, the medicine I was taking instead of having surgery, as a result of that, I'm doing well. And the doctor wrote in the notes that he has no other ENT concerns at this time. So what the petitioner is asking you to do is to take this information that was given to the NCAA, which is the contemporaneous information that the NCAA has to make its decision on, and saying it was bad faith for the NCAA to look at this and say Mr. Chambliss was not incapacitated. That's not bad faith, Your Honor. That's simply recognizing what the letters in black and white say in the medical records. It's recognizing that he practiced.
Now, what the letter says, Mr. Rogers.
Well, the letter's not contemporaneous, Your Honor. The letter's from 2025. Under the bylaws, the NCAA has to look at contemporaneous medical evidence. And so if they look at the contemporaneous medical evidence, there's no support for that. You've heard more than that. They've put more in front of the NCAA and you since then.
Where he explains all of what he was going through in notes. He didn't say exactly what he said in his letter, but he's a doctor, he knows what he did and what he didn't do, and he put it in, it was contemporaneous. It's covering the time period we're talking about, 2022.
Your Honor, it is the NCAA's position that a letter from the doctor that was provided at the NCAA's request in 2025 is not contemporaneous. The NCAA applied the rule as it has for decades pursuant to the membership's adoption of those particular measures, and the membership says it has to be contemporaneous. And coming in later afterwards and saying, I'm going to come in front of the judge with this other information that's not contemporaneous, or I'm going to put it in front of the NCAA and say, I know the rule says contemporaneous, but consider this non-contemporaneous evidence. It simply isn't bad faith for the NCAA to apply the rule as it's stated, as it says with respect to what's contemporaneous. And so,
Didn't Ms. Henderson try to modify that and make the rules change in contemporaneous?
not at all. Not at all. Her affidavit says that the reason why the waiver request was denied was because based on the contemporaneous documentation, there was no support for that. And Your Honor, I can understand how you might be confused because what you've heard today was stuff about 2024 and 2025 and what Mr. Chambliss told, you know, the expert witness a couple of days ago when he met with him. But it is not bad faith for the NCAA to make a decision based on contemporaneous medical evidence because you've heard some other information that's not contemporaneous. And just based on that record, there's just simply no way to say that's bad faith. And Your Honor, bad faith does not mean that it could have been decided differently. It doesn't mean that it might not have consequences to Mr. Chambliss that he does not want. The question is whether the court can issue an order saying that the NCAA engaged in bad faith, and they can't do that, particularly when it's simply not tenable, this position that, you know, he was incapacitated because of this condition when he played at such a high level and, you know, was the runner-up for the D2 Heisman, I believe. That's just simply not tenable, Your Honor. All right, moving to the evidence and to the arguments that Mr. Chambliss, before I say that, Your Honor, I also want to point out there's another reason why the NCAA's decision isn't bad faith. There's something else that you should consider, and that is that there's nobody here from Ferris State who said that he was incapacitated.
He what?
That he was incapacitated. Nobody here. There's no affidavit. There's no testimony. What we have is a letter that Ferris State provided in conjunction with the NCAA's waiver request. And what does that letter say? The decision was based on his developmental needs and our team's competitive circumstances at the time. Your Honor, that doesn't say that he was unable to play. That doesn't say he couldn't compete.
She goes on to say in that sentence, and there were other medical issues that he had. And she wrote another letter that's in the record that says that he was incapacitated, in her opinion, Dr. Higley did in 2022, and Coach Anise said the same thing in his letter, that he was not able to play in 2022.
Your Honor, the evidence.
That's what the letter said.
Your Honor, I don't recall that specific statement from the letter. There is a letter from someone at Ferris State that talks about how they had software issues, and there's information that might be relevant to his medical condition, but because of the software issues, they're unable to get it, and we'll supplement it. We'll keep trying to get it. But Your Honor, I'm reading from my notes the quote from Ms. Higley's letter, and when she's talking about the decision to quote unquote redshirt him, and she says it was based on his developmental needs and our team's competitive circumstances at the time. The court simply can't look at that statement and say that the NCAA made a bad faith determination that he did not meet the requirements of the bylaws. Your Honor, on the likelihood of success of the merits, the first factor, there are three reasons why the petitioner cannot satisfy the burden for getting an injunction. He misrepresents the duty under the tort of good faith. He offers no evidence of bad faith. And then he misrepresents the nature of the Committee on Legislative Release guidelines. So the breach of the good faith, the duty of good faith, is bad faith characterized by some conduct which violates standards of decency, fairness, or reasonableness. And the appellate courts of this state have said it requires a showing of more than bad judgment or negligence. It implies some conscious wrongdoing because of a dishonest purpose or moral obliquity. Your Honor, to say that the NCAA denied the waiver request because of the contemporaneous documentation, and when that contemporaneous documentation says nothing about him being unable to play, to say that the NCAA's decision was the result of conscious wrongdoing or a dishonest purpose is simply, it's not reasonable, Your Honor. They did what they've done for decades. They did what the membership told them to do. Take the information, look at what's contemporaneous, and see if it supports the request, and it simply doesn't. There's nothing dishonest about that determination. There's no evidence that it's inconsistent. They haven't given you any evidence that there's another student athlete who was on similarly situated and the decision was different. There's no evidence that the NCAA has made this decision any differently than they have for any of the other athletes. We can talk about people in the news, we can talk about Carson Beck, but without any evidence for this court to see that the circumstances are similar, that's not relevant to the court's determination today. And in the absence of that, what they want to do is they want to change the standard. So I just read to you what the courts have said bad faith requires, and here's what Mr. Chambliss argues. The duty of good faith and fair dealing charges the NCAA with the responsibility to help Trinidad find a path. That's not the law. The duty of good faith and fair dealing says you have to avoid doing something to prevent someone from realizing the benefits of the bargain or from performing. It's not to help them. There's not a single citation in any Mississippi case law in support of that statement, and because there isn't any. The NCAA did not have any duty to help any particular student athlete. Their duty was to apply the bylaws that the membership adopted to be uniformly applied across the full membership. That's not the law. They're trying to convince you that the standard's different because they have to in order to get this injunction. He claims that the NCAA need not be so heavy-handed since it could have, in fairness, considered his request. Your Honor, the duty of good faith has no such requirement. The fact that the decision could have been made differently does not mean that the decision was the result of bad faith. He goes on to say the NCAA should recognize that good faith and fair dealing, it demands exceptions be made. No citation. No Mississippi court has ever said that. No state court looking at the duty of good faith and fair dealing has ever said that it includes a requirement that you make exceptions for someone. It's not the law. They go on to say, Fair State considered him redshirted in 2022-2023. That's just a statement. And then they go on to say, even though they may not have filed the proper redshirt paperwork for the year 2022-2023. That is an acknowledgement. That is an acknowledgement that there's no evidence of that. The testimony earlier was that he trusted them. Well, Your Honor, he may have trusted them to do that, but they did not do that. And because they did not do that, it's not possible for the NCAA's decision on the waiver request that's reflective of the absence of that evidence to be bad faith. They say, since he has no right to communicate directly with the NCAA, any documentation failures by Fair State are not attributable to him. They are. He's a third-party beneficiary of the contract between Fair State and the NCAA. To say that they're not attributable to him, that doesn't make sense. His rights come from that contract, and if Fair State had obligations under that contract that they did not comply with, that doesn't make the NCAA's decision bad faith. It means that the NCAA's decision is based on evidence which includes their failure to come forward with any such evidence of incapacity. So, Your Honor, I mention all those because when you look at them collectively, what they tell you is that the petitioner's lawyers, they understand that the law is against them. What they're trying to do is recast that tort in terms that aren't supported by Mississippi law in hopes that you will grant the injunction. And then, in addition to misrepresenting the tort, then they go on and they offer, arguments that are just completely unsupported. Mr. Byers repeated one, concocted a false reason for denying the waiver request. That's not true. No false reason. That what they did was they applied the plain language of the bylaws and made a determination that there was no evidence, no contemporaneous evidence of incapacity. They say it ignored its own policies requiring the use of contemporaneous and non-contemporaneous evidence. Not true. They considered the contemporaneous evidence. They considered the non-contemporaneous evidence as it supported the contemporaneous evidence, and there's nothing from 2022 to support their position. You've heard talk today about how they failed to investigate from a medical perspective and failed to hire a doctor. That's not what they were required to do. The court may require that when the court has litigants in front of it and they're advocating legal claims and the court's trying to determine whether a particular legal claim has been proven, but that's not the court's analysis today. The court's not making a decision on the waiver. The court's looking at whether the NCAA's decision was bad faith, and there's simply no evidence of that. They want to talk about they unfairly excluded the Howard letter. No, they didn't. They didn't exclude it. The bylaws say it's not contemporaneous. So they credited it accordingly. That doesn't mean that it was excluded. The fact that they didn't rule the way that Mr. Chambliss wants them to is not evidence that it was excluded. Failed to apply the bylaws for his benefit. There's no obligation to do that. You apply the bylaws based on what they say. You don't apply the bylaws to anybody's benefit or to anybody's detriment. And then they talk about false and misleading public statements, which are completely irrelevant which are both untrue and completely irrelevant to the court's decision today. And then lastly, the NCAA offers no information that contradicts or disputes the submitted evidence. That's not what the NCAA is charged to do. The NCAA is charged to make the waiver determination based on the evidence that's in front of it. Your Honor, there simply is nothing, and you haven't heard any talk about precedent, you haven't heard any talk about what the Mississippi Supreme Court's done in a similar situation, and that is because to grant an injunction that would require you to say that the NCAA consciously committed wrongdoing and engaged in a dishonest purpose, when it looked at medical records saying, I'm doing well, I'm fine taking these medications, a decision not to come back for the follow-up appointment, and then a meeting after the season saying that you're doing well, to say that the NCAA looked at that and said he wasn't incapacitated, and that's bad faith, is simply not reasonable. Your Honor, I want to move next to this conversation of, this discussion of irreparable harm. What you heard was he would benefit from another year. Every student athlete can say that, Your Honor. If you can hire a lawyer after an adverse NCAA decision and come into court and get another year of eligibility based on the argument that it would really benefit you next year, I mean, you're going to have a lot more of these hearings. But that's simply not the law. I mean, that's not the standard for determining whether he was harmed. You haven't heard any argument about it today, but in their brief, they rely on a case in Alabama called, the plaintiff's name is Boyd, I believe, and the site is 369 Southern 2nd at 556. And they cite it in support of their position. And the Boyd court found that as far as Alabama is concerned, the right to be eligible to participate in college athletics cannot be viewed as a mere speculative interest, but it is a property right of present economic value. That's what that case says. And the next sentence of that case says, not all courts agree with that. And then that opinion cites a Mississippi decision called Gillard, 352 Southern 2nd at 1081. And this is what the Mississippi Supreme Court said. The basic decision of the case then is the simple statement that Gillard's right to engage in intercollegiate football is not a property right that falls within the due process clause of either the Mississippi or federal constitution. So for purposes of irreparable harm, they cannot establish that he has been deprived of any property right to play college football because there is no such right in Mississippi. And then their arguments about benefits and fairness are simply not legally cognizable arguments to support irreparable harm. A college athlete is not irreparably harmed when his or her eligibility expires. Eligibility, it expires for everyone. The argument that I'm harmed because I can't play anymore is an argument that every single college athlete in every single sport could say at the end of their eligibility. That there has to be more than I'm harmed because I can't continue to play. But that's really what you've heard today. If I play, I may improve. If I play, I may get a better draft position. If I play, my numbers may improve. The team may do well. Those are all laudable things for Mr. Chambliss to aspire to, but the question for the court is whether the NCAA has harmed him in some legally cognizable way by applying the same rules that it has applied to everybody else and said, you've got to have your 4 years played and your eligibility has to all occur within a 5-year period from when you start. That's not unfairness to him. Those are the rules. Those are the rules that Ole Miss, as a member of the NCAA, adopted for everyone to follow. And it is not bad faith for the NCAA to apply the rules that the membership has told it to apply. Your Honor, and the other reason I mention this property right is, in the absence of any concrete evidence of irreparable harm, all he has left are all these monetary damages about all the NIL money and revenue sharing money that he won't receive. But Your Honor, it's black letter law. I'm sure Your Honor is familiar with it. You can't get an injunction when you're talking about monetary damages. Those are all damages that can be recovered in a non-injunction context when the court has the benefit of evidence and full testimony and a full record. The fact that his harm is that it would benefit him if the decision was different is speculative, and it's not the kind of argument that the court can credit and comply with Mississippi law. Moving to the last two factors, Your Honor, opposing counsel was talking about how there's no harm to the NCAA if you grant this injunction and allow Mr. Chambliss to have another year. That is simply not true. The NCAA it's not the employees up in Indianapolis who are making the decision. The NCAA are the member institutions that decide on the rules that apply to everybody. So if an athlete can go to court in his or her local community and get a different ruling and get a judge to disagree with the NCAA and take that, arrogate into that judge's own discretion to make that decision, that will significantly harm the NCAA. It will change the face of college football because the people who make the decision are no longer the people who are tasked with making the decision. It's the judges in Baton Rouge, in Fayetteville, and Tuscaloosa, and Oxford, and Starkville, and how they would make the decision if it were up to them. And to say that that's not going to harm the member institutions is simply ridiculous. That's on me, Your Honor, sorry. That's simply ridiculous. They will be harmed. And everybody who's an Ole Miss fan would view themselves as being harmed if this were playing out in Starkville or Baton Rouge, and a judge was coming along and saying, I don't care what the rules that were adopted by the membership say, I'm going to let him play. To say that that's not going to harm the member institutions and harm true college football fans around the country is ridiculous. It will absolutely harm them. It will change the way that eligibility determinations are being made in a way that is consistent and subject to individual judicial determinations and individual state laws. So we categorically reject the notion that the other teams who have to abide by the same rules, who have heretofore not changed the rule, and there's no evidence, they haven't brought you any evidence that this particular circumstance was applied differently elsewhere, as I said, that's harm. And you know, Mr. Chambliss may have to play in the NFL as opposed to playing at Ole Miss, and he may, to the extent he views that as harm, that is up to him. But we reject the argument that the member institutions who've decided that these are the rules that everybody has to play by are not going to be harmed if an individual athlete gets an exception. That's simply not true. Your Honor, there have been, in the last week, 2 state courts who have been in a similar situation to you. And they have looked at all of these arguments, and they have considered the point I just made about what happens to collegiate athletics generally. And they have made some decisions that I would like to point out to you. In the Bediaco case that my colleagues handled successfully just in the last few days, I believe that decision was handed down on February the 9th in Tuscaloosa County, Alabama. This is what the judge said. Based on the plaintiff's arguments, the court believes it likely, if not inevitable, that the court's issuing of the injunction here would be used by other plaintiffs before other courts as evidence of the defendant's arbitrary and capricious enforcement of its rules. Thus, the NCAA would suffer hardship. The Bediaco court recognized that what happens when a ruling, we believe that your ruling should be to deny the injunction because of the law, as I said previously. But I'm also wanting to talk to you, Your Honor, about the context of your decision and what the state court in Tuscaloosa recognized when it made the decision that this individual was not eligible to compete in collegiate basketball was it recognized that if it said otherwise, then other schools in the NCAA.
Is that the guy that had played pro for about 6 months or a year? He came back to Alabama and they put him on the team?
That's correct, Your Honor.
So it's a totally factually different case from what we're talking about here.
It's not identical factually, but the similarity is that was a decision based on the NCAA's rules. So anytime a student athlete gets a judge to rule contrary to the NCAA's rules, that's going to encourage other student athletes to challenge other rules. Some court somewhere is going to have someone come in and say, I know I was supposed to have a 2.5, but I had a 2.4, but here's why. There was this and there was that. I'm using it as a hypothetical. They go to court, they bring their parent, they bring a doctor, they bring an administrator, the cameras come in, and they argue to the judge, Your Honor, we don't care what the NCAA.
Bring them here, they came on their own.
No, I hear you, Your Honor. You're right, but well, my point is it's a template. It's a template. It is a decision that will resound around this country. People will say, okay, when I have a star linebacker, when I have a star quarterback, when I have a star running back, if the NCAA says he's not eligible, here's what I'll do. I'll pay the filing fee. I'll get my mom and dad to come into court. I'll get a doctor to come and provide evidence that's not contemporaneous or something similar, and I'll see if the judge says yes. And every single time a judge says yes, Your Honor, that's going to encourage additional people to come in here and do it. And that is significant harm, not just to college football, that's a significant harm to collegiate athletics. Tennis players are going to do it. Soccer players are going to do it, particularly if there's money on the line. I'm sure you could beat me in tennis, Your Honor. Your Honor, and just to finish my point, there's another case, and this was a state court in Ohio called Grabowski, and this decision was handed down on February the 6th, where the duly adopted laws of a voluntary association provide for the final settlement of disputes among its members by a procedure not shown to be inconsistent with due process. Its actions thereunder are final and conclusive and will not be reviewed by the courts in the absence of arbitrariness, fraud, or collusion. Courts will not interfere with the quasi-judicial decisions of voluntary decisions unless there's fraud or arbitrariness or collusion. And lastly, the court said this, Your Honor. This is the Grabowski decision, Your Honor, and it just came down recently, and if I may approach, I can hand it to you.
There's another case out of Ohio, Glasser, I think it is.
What was the other one, Your Honor? Your Honor, the quote I was about to read, should the court grant an injunction allowing student athletes to receive court intervention when there is a decision or rule that they do not like, then why even have bylaws? When they do not need to be followed, the courts will take away the power of the voluntary self-governing associations and their decision-making process. The court would then become the appellate process superseding the authority of the NCAA. Your Honor, what these two judges have recognized is that this is more than about whether an individual student athlete may be able to improve their statistics or make more money if they get another year. It's about who decides whether someone is eligible. And for decades, there have been staff people at the NCAA who have taken the rules and guidelines from the membership. They have applied those to the best of their ability. They have reviewed precedent to confirm consistency, and they've made decisions over the years that have ensured that everybody plays by the same rules. And what we're facing here today is a request that, well, when those rules don't get me what I want, then I want to be able to go to court and I want to convince the judge to make it different. And Your Honor, obviously it is in the court's power to grant the injunction, but as I said, the reason to deny the injunction is because it hadn't been proven. So I'm not suggesting that what I'm telling you is the reason to deny it. The reason to deny it is because it's not legally sound. But I am telling you that every ruling, as those two courts recognize, every time a state court judge or any judge makes a decision to reject the ineligibility determination of the NCAA, particularly one that is just facially sound, it erodes the NCAA's ability to manage eligibility determinations and ensure that everybody plays by the same rules. And if that happens, this will not be the end of it. This all started at my law firm with our involvement in the Pavia decision back in 2024. And you can actually read that decision, and Judge Campbell says this case is limited to Mr. Pavia. And I believe that Judge Campbell believed that when he issued that decision. But there have been over 40 lawsuits since then. That was a federal decision, Your Honor, but that federal decision spurred over 40 lawsuits in state and federal court. My colleagues and I have been in West Virginia, in Texas, in South Carolina, Alabama, Tennessee, all over the place, and other law firms representing the NCAA throughout the country. And I mention that because, in all fairness to Judge Campbell, he was incorrect. It was not limited to Mr. Pavia because other schools in the SEC, other student athletes saw him go to court and get a ruling that was contrary to the decision of the NCAA, and they said, I'm going to do it too. And as opposing counsel said, Mr. Chambliss has a high profile. He's because of the fantastic season that he had and people around the country enjoying watching him play, people are watching this proceeding. People are watching to see what happens here. And as those courts recognize, if the decision is you can file a complaint and a petition, you can move for an injunction, and a few days later you can go into court and you can put on a little mini trial and you can ask the judge to give you a few more years. If that decision comes, there will be harm. So finally, Your Honor, the decision for your purposes to decide whether this is a bad faith breach of the duty of good faith and fair dealing. Under the law, you have to look at the NCAA's bylaws. And when you look at those bylaws, this NCAA applied them fairly. There's been no proof to you that that decision was made inconsistently. There's no evidence of dishonesty. There's no evidence that anybody involved in the NCAA has any axe to grind or any opposition to Mr. Chambliss. This is simply the NCAA saying, under our bylaws, and based on the evidence that you provided, you have not satisfied the criteria for the waiver. We ask that you deny the injunction because of the absence of that evidence, and we ask that you reject opposing counsel's characterization of this as some isolated decision that is all about Mr. Chambliss's fairness and benefits, and recognize the greater context in which your decision will be received. Thank you.
All right. Mr. Liston?
Yes, sir. Yes, Your Honor.
This is rebuttal, I hope.
This is rebuttal. Your Honor, as Mr. Minor knows, this is not a criminal case where the court's required to find proof beyond a reasonable doubt. This is a civil case. It's controlled by standard preponderance of the evidence. And on this motion, all the court has to find is that we have a substantial likelihood of success on the merits of Trinidad's claim. And we put on that evidence today of the merits. That's what today was about. And I will suggest to you that we more than prove that we have a substantial likelihood of success. As a matter of fact, the only medical evidence that's before this court is in Trinidad's favor. It is not rebutted by anything the NCAA has offered, except an affidavit written by a lawyer who is not a doctor. And I'll get to in just a second talking about how the NCAA committed bad faith. Now, nobody wants to play a football game where it's being refereed by crooked officials, okay? And likewise, nobody wants their eligibility decided by an adjudicator who's already in their mind opposed to granting the waiver, an unfair adjudicator. I tried a lot of insurance cases in my life, and that's where you typically see bad faith in insurance cases. If this was an insurance company with just the admissions in their brief and just Ms. Henderson's affidavit, it would be a slam dunk bad faith case. They have a policy. I can't believe they even wrote this down. They have a directive that says, bylaw 12, that's the bylaw we're operating under here, section, additional seasons of competition, where they instruct their staff, and make no mistake, these decisions made by their staff, not by their member institutions all around the country, they instruct their staff to deny requests for additional seasons of competition. That's before they even heard the evidence. That is a bad faith state of mind. Mr. Minor's a really good lawyer, but he hadn't practiced law in Mississippi in a while. Maybe he forgot what our law is, so I would like to kindly correct him. The duty of good faith is breached when someone who has a contractual right is either treated unfairly or unreasonably. And the leading case on bad faith in Mississippi is the decision in Cenac versus Murphy. That case was decided in 1992, and the Mississippi Supreme Court says this: the law prohibits a party from interfering with the other party's opportunity to realize the benefit of the contract. But the law also requires the NCAA, quote, to take affirmative steps to cooperate in achieving this goal, end quote. Now, that does mean the NCAA owed him a duty to try to help him find a way to get his additional season, his fourth season, and evidence of that is they thought enough of that they put that rule in their rule book. Well, if they're not going to help the student athletes who they claim they exist to benefit, navigate these Byzantine rules that they have and find ways to help them achieve what every other football player in America gets, 4 seasons of competition, then what good are they? Why do they exist? That's nuts. It's crazy. And listen to what they said on January 9th when they denied the waiver again on appeal the day after the Fiesta Bowl. I'm quoting from what they gave on this. Quote, the purpose of extension legislation is to ensure 4 seasons of participation opportunity, end quote. So these 4 seasons, that's a valuable benefit for a student athlete that's in this contract, okay? And he is a third-party beneficiary of the contract. I would suggest to the court 4 seasons of competition is the only benefit these bylaws afford Trinidad as a student athlete. And they had a duty to help him obtain that. And that's why they have a waiver rule. here's how they committed bad faith. And this is all we know right at this moment before we start a deposition process, which is going to be fabulous. But, and I couldn't believe they wrote this. It's in Ms. Henderson's affidavit. They retreat from this argument that I've heard again today, that the documentation was not contemporaneous. Matter of fact, their brief says, hang on, don't interrupt my closing.
No, just for purposes of the record, Your Honor, this is not a full rebuttal to my comments, and I just, he's making arguments that were not raised earlier, and I would ask for at least the opportunity to at least briefly respond.
Well, you have raised the issue that they didn't prove bad faith, and what he's trying to do is rebut that. That's why we broke it up. He was gonna open, and he's gonna close, and so I'm gonna let him proceed.
Thank you, Your Honor. That's exactly what I'm rebutting, the contention that there's no evidence of bad faith. The evidence of bad faith
Go
is,
back to Ms. Henderson.
yeah, Ms. Henderson, her affidavit. Here's what it says. Well, there is contemporaneous documentation. There was a record right before the season started and a record right after the season concluded. And so they don't claim in this submission that there's no contemporaneous documentation. They admit that there is, right? And then they say this: we have a rule that if documentation is submitted later in time, they call it non-contemporaneous documentation, that we can ignore it and not give it any weight if we think it conflicts with the contemporaneous documentation. Now, I have read the bylaws, I've read their directives, I've read their policies. There's nothing they've ever written that says they can do that. Matter of fact, it says the opposite. In determining eligibility, they have to judge it on the totality of the circumstances. So they made up a rule to justify the complete exclusion from their consideration of Dr. Howard's letter in October 2025. And it's worse because there's nothing in Dr. Howard's letter, even under their own newly made up rule, that conflicts with what's in his medical records. His letter merely gives a professional opinion which expounds on the facts of treatment that are recorded in his medical records of 2022. So, bad faith, selective choosing of what evidence to believe, what evidence not to believe, and you know, it's clear. They use the word not credible. What they're doing is they're calling Dr. Howard a liar. They're just saying, we're not going to believe this. We think you've made this up. We think Ole Miss made this up.
Contrived.
Yeah, contrived. But we didn't do that. We didn't have to do that because the facts are in our favor. And the facts are historical and provable. I mean, public knowledge facts. So the bad faith that we know of at this moment, before we can conduct any discovery, take their depositions and get into their email boxes, is that they have admitted in their brief and in Ms. Henderson's affidavit what they did and his bad faith. Because it's not very reasonable to exclude completely, give no weight to the opinion of a treating physician that actually saw him, actually looked in his mouth in 2022. Any treating physician, as Your Honor knows, in a court of law, could come in here and testify to the conditions a patient had in 2022 and express an opinion in 2025 based on that information. That's what doctors do. And if they're asked new questions like, well, do you think this injury incapacitated him? He would be allowed to express that opinion. They completely shredded that letter. Didn't even consider it. And they admit it. Ms. Henderson says we gave it no weight because it's in conflict. It's not. And nor did they ever tell us how it conflicts. Mr. Minor says this is not about fairness. It's all about fairness. Because that's what the duty of good faith and fair dealing is. It's a fairness principle. I'm shocked they called no witnesses today. I'm shocked they have no medical evidence that rebuts the medical evidence we put on through Dr. Howard's letter and Dr. Dye's testimony. You would think that they would have had Trinidad's records reviewed by their own medical people, because they have in their building in Indianapolis, they have a sports science institute with doctors in it. So if they would have had that proof, they would bring it in here today to show their good faith. But it's bad faith not to even attempt to get an opinion like that. He was clearly incapacitated in 2022. We've heard that testimony. The NCAA, and this is another aspect of their bad faith, they just looked at this as a case of tonsillitis. That's it. I mean, they didn't take into account the chronicity of that disease. They didn't take into account the hypertrophy of the tonsils and the adenoids. They didn't realize, and you think they would, that these tissues, when they swell, block his ability to breathe. And they didn't take into account his sleep apnea, which fatigues him every day and fatigued him every day until he finally had his surgery. And this is despite the fact that they publish materials that talk about how important sleep is for college athletes and all of the dangers that arise when college athletes have sleep disorders. They say, their words, not mine, it increases the risk of injury for the athlete and it increases the risk of injury to the teammates. They even have meetings, they call them.
Bad athletes that cause good athletes to get hurt.
That's exactly right. And their own writings recognize that, okay? But they're ignoring their own policies now just to reach this result. Trinidad is different from every student athlete that I've read about,
And I say judge, I mean,
Yes, sir.
judge.
Yes, sir. Trinidad's different from all of these cases Mr. Minor's talking about. He's not trying to change the rules. He's not going to upset college football or tear down the structure of the NCAA. He just wants them to apply their own rule fairly. And that's what the duty of good faith requires. And, go back and look at their brief. Go back and look at Ms. Sender's affidavit. They didn't. And they admit that. There's a break in the case law in situations where student athletes go to court against the NCAA. Before the Alston decision by the U.S. Supreme Court and Judge Kavanaugh's just scathing concurrence, and before NIL, most all the cases you find are decided in favor of the NCAA. With courts saying things like, it's not our job to interfere in the decisions of a voluntary association. That's just not the law anymore. There are 4 big cases out there since Alston. They were all, I think, federal court decisions. And the courts say this uniformly. The NCAA rules are a contract. Student athletes are third-party beneficiaries of that contract. And that the NCAA has to apply these rules fairly. And then the courts say, as to some of the things Mr. Minor mentioned, that the argument that some hypothetical student athlete other than Trinidad is going to be harmed does not outweigh the real, proven, imminent, and impending harm that the student athlete in the case is about to experience. They've also rejected the NCAA's arguments that were made here again today about what's good for the public. And the courts now say it's in the public's best interest that student athletes get to play their 4 years, and it has benefits for the student athlete, for their teammates, for their coaches, for the entire community. And we know that to be true. We see that happen every football Saturday in Oxford, Mississippi. At this point, monetary damages are not fully quantifiable, and they're not even really knowable. I mean, I'd bet my house on the fact that Trinidad makes next year $1 million in just third-party NIL deals. I just know it's going to happen, but can't prove it yet. Can't prove that yet because he's.
Mississippi passed a law that said that, the NCAA cannot interfere with the, making of this money by a student. In
That's
the state of Mississippi, it pretty much follows US versus Austin.
yeah. That
NCAA Austin case.
That's exactly what the law says. But here's the thing. In order for him to legally receive NIL money, he has to be eligible. That's the condition for it. So any eligible athlete can do an NIL deal with a third party, and the law, which is the public policy of the state of Mississippi, says the NCAA cannot interfere with that and cannot punish either the athlete or the institution. So if we're looking for what's good for the public, look at that public policy and our NIL statute. Trinidad is not a professional athlete trying to come back to college. He hasn't even played his 4 years. It's absurd to me, just make this comment, that a professional athlete would try to come back to college. I know I wouldn't take that case. But any of those decisions that involve pros trying to come back to college, completely inapposite to what's going on here today. I just want one final thing. This idea or notion that we're the NCAA. We make our rules. We decide what evidence we want to consider in our rules. And then we make a decision. And that's our right to do it. And the student athlete doesn't have a say-so in the matter and certainly can't come to court and challenge it. That's unconscionable. I mean, their rules govern his fate. He didn't even get asked about these rules. You think these are good rules when they were making them? I mean, the next year of his life, the ability to develop as a college quarterback, probably millions of dollars of compensation to him through either revenue share or NIL are at stake. I mean, whatever this court decides today is going to change the direction of his life. His college career is either over or he gets to stay. And it's I said unconscionable, but to me it's really offensive. It's offensive that someone would say he has no right to stand up for himself in this court. Thank you.
The court has heard the arguments of the parties. I'm going to retire to Chambers and review my notes, the pleadings, read things that have been filed, words that have been spoken here, and arguments. I'm gonna do my best to make a ruling this afternoon. But it's not gonna be till I have a chance to look at all this and make an intelligent and fair decision based on what I think the law is. So, we're gonna be in recess, you free to stay, you free to go.